Hi, and welcome to today's segment of The Power of Money. I'm your host, Michelle Graves, the Money Lady. Since 1976, I have been working to educate and inform the American consumer about what they need to do to keep their financial affairs in order. And I am delighted today to have an extraordinary guest on my telecast. And so you want to sit down, call your friends right now. This is serious. And the information you're going to learn today is going to be, for many of you, life-changing. So I'd like to introduce my guest today, and her name is Kathleen Marteney. She specializes in estate planning and wealth creation with a firm in Cincinnati, Ohio called Resonate. And we're going to be talking today specifically on the subject of estate planning and women. And so what better person to have than an individual who is a woman in a very, very specific industry. And she will be sharing with us for the next hour why you need to have estate planning. I know for many of you, the thought of it makes you very nervous. But I'm here to tell you that it is foundational and fundamental to your financial foundation. So without further ado, I am going to present to all of you today, as my viewers, Kathleen Marteney. And how are you today?
Just fine,
I'm
Michelle.
so glad to see you, and so glad you came in to talk to me about such an important subject. Where do we want to begin? Give me a little bit of background about yourself.
Sure, and thanks for the opportunity to join you today.
I'm delighted.
Actually, I'm a UD grad.
Okay.
I started in the industry about 17 years ago, and back in 1995, I've lived all over the country. I've lived in New England, I've lived in the Deep South. I grew up in the Midwest, and when I came back about 17 years ago is when I started in the personal side of financial planning. And I spent the first 15 years with Lincoln Financial Advisors and its predecessor Cigna Financial Advisors, and about 3 years ago I partnered with Barb Culver at Resonate, an independent firm that specializes in planning. And I would say, you know, early in the business I very much gravitated toward planning as being a very key element and central to the client relationship, and within that the estate side of things, I think, was, was of particular interest to me, particularly for women, because if it wasn't done right, the implications were huge.
You're correct. They are huge. So let's talk about estate planning and women. Let's open up with just a question. What is estate planning?
Sure. Estate planning in its simplest form is really about making sure your affairs are in order. And affairs can be everything from the financial aspects, and that's probably what most people think of when they think about estate planning. You know, the property that they own, their assets, their home, their house, their cars, their business, an investment portfolio, their retirement plan. But there's many other aspects to estate planning. If you have minor children, the opportunity to name a guardian, and also the opportunity to designate someone to act on your behalf if you become incapacitated and can't make your own decisions. Those I'm sure we'll get into in more detail in a minute. The durable powers is what they are. And there's also a living will, and the living will really gives you the opportunity to specify your intentions with respect to life support and life-sustaining use of equipment if you really are your brain's no longer functioning.
You know, those are such tough subjects and areas, and I have found, in terms of my private practice as well, those are areas that people don't feel particularly comfortable addressing. In so many cases, they prefer to just kind of look aside. So if we look at an estate plan, and you've talked about getting your affairs in order, and primarily financial, but not necessarily financial. So let's start with who needs an estate plan. A single young woman with no children, does she need an estate plan?
Absolutely. In fact, everyone needs an estate plan. I don't know of anyone who doesn't. And again, just what we talked about a moment ago, having advance directives set up, and that's the legal term, but that's really a durable power of attorney for health care, for financial reasons, and a living will. So regardless of the assets that you have, those are just essential elements that everyone should have, and that's to give somebody the opportunity to make decisions for you if you can't. But back to a single woman. In particular, you know, people do and talk about estate planning with regard to their assets again. So often it's something that I think needs to be revisited throughout life and not just be event driven. Doing an estate plan is not something you do once and put on the shelf and never look at again, but something to revisit on a very regular basis. Say
like what would you say?
I would say, you know, maybe every 3 years, 5 years at the most, perhaps around certain life events, births or deaths, or perhaps divorces, or you know, if an addiction problem or substance abuse comes up in a family, you know, so there's the gamut of reasons to revisit it. But back to your question about single women a minute.
Yes, yes.
You know, as I think it's important to do it and revisit it again as life evolves. For example, you might start out and think, well, I'm going to leave my assets to my parents, and as the parents pass away, perhaps to siblings. And as life happens, and you know, maybe the siblings have less of a need, perhaps it's nieces and nephews or other people that are important in life. May even, you know, ultimately become, you know, significant others or friends or, you know, institutions that have touched you, on the charitable side of things, if that's, you know, it's often an important piece and often an overlooked part.
In dealing with a single female.
And dealing with everybody,
Really?
actually.
Okay, okay.
Yeah.
What about, because we're seeing more and more divorces and remarriages and then divorces, you're looking at generational divorcing and remarrying, either, and not necessarily divorce, maybe the death of a mate and then remarrying. What would you recommend that a person do in that type of situation?
Sure, Michelle, and I can tell you, as a widow myself,
you are a widow.
I am.
Goodness gracious.
It's going to be 15 years next month, and my husband died very, very suddenly on a business trip.
No pre-knowledge, no? Just
no, nothing. I got a phone call, and he was in the hospital. So I can tell you that working with widowed women is a huge passion of mine, because I've walked that journey. I know what they're going through because I have been there, and I think it's important to for any person who's challenged by a sudden death or sudden loss of a mate, knowing that you don't have to make decisions right away, or there are certain things, of course, that you can take care of, but it's important to have the time to really kind of, you know, get back on your feet and be able to focus and understand the implications of some of the decisions that, you know, you may be making. But it's not something that you have to feel pressured to do.
I would have to agree with you. My standard advice to women that are newly widowed is, for the first year, you're not even functional. And so my desire is to make sure all things are in order so that when these things do come, that at least you can go into a neutral position and just try to get through the day. And I'm sure you can certainly relate to that, trying to get through the day.
Right. You know, it's interesting, and it's hard to understand what this is really like, and like most things, until you actually live it. You know, but it does. Life changes in an instant, and things that we thought we could take for granted, like tomorrow, suddenly become nothing is
Right.
out there to be taken for granted. But you're right. There is certainly a recovery period with regard to just getting through the day, and it's
Yes.
almost as if you're going through the motions of life, and you're watching your life happen around you, but you're not a part of it.
Probably to help you to get through the pain,
Yeah.
that you just simply take a step outside of yourself and just go through that. Certainly my mother, who was a widow, she's since remarried, but when my father died, I watched her become a person who literally was just going through the motions. And that's been some time ago, but that was my birthing into that whole area of widows and death and dying, and having your affairs in order, which is so essential with estate work,
Right.
that you're not going to be too functional. So you would want to make sure that all things are in place. So let's talk about what are some of the things. I know we've kind of tossed around some terms, but let's, for the benefit of those who are viewing, let's talk about the foundation of it all, which is your will.
Sure.
Okay.
And the will is clearly, the best place to start, and that's just where you are, one, naming an executor or an executrix, as if it's a woman, to handle things when you're no longer here. And you designate someone to just settle all of your affairs for you. You also can dispose of all your property in a will if you choose to, be it personal property, family heirlooms, or, just, certain, whether it be, a certain collection of art or, anything that may or may not be very material, but it has great sentimental value. You can dispose of all of your property in your will if you choose to. You can also have property pass through other means, and I don't know if you want to talk about that now or
We'll
not.
see how our time goes, because I think
Sure.
it's important.
Again, if you have minor children, the will is where you designate a guardian. In the absence of doing that, the courts will decide that for you, and it may or may not be who you would choose to raise your children if something happens unexpectedly.
So that's basically, with a will, we're looking to make sure that your instructions are clear and assets are, the proper disposition of the assets are stated in print.
Exactly. For
Now,
assets that pass through via a will.
Right. Now, without a will, and we do know that there are millions of people that cross over without a will, what does that mean?
It means that you're governed by the laws of intestacy of the state in which you pass, in which you were a resident of. And in the state of Ohio, that means if you're a married person, that all of your assets do pass to your spouse.
Okay.
If you have children, then it's half to the spouse and half to the children.
Even if that's not your wishes.
Exactly. Exactly. And again, that's with property that passes through a will.
Okay.
If you have beneficiary designated assets, for example, retirement plans or IRAs or annuities or life insurance, you designate a beneficiary on those assets, and of course they will pass that way. If you have jointly titled property, for example, joint with rights of survivorship, which is the most common method of titling a home, for example, then that property passes to the survivor, be it the spouse or if it happens to be someone else, that's who winds up with the property.
Many times I have found over the years that people make assumptions about how things will play out, therefore they don't see the need for a will. Have you found that to be the case in your practice?
I have. In fact, probably all too often there is a tendency for people to want to just trust so to speak, that so-and-so knows and understands my wishes. And a minute ago you mentioned the idea of remarriage. And
Yes.
with the rate of divorce in our country and the number of blended families, you know, thorough estate planning takes on a whole new level of importance. For example, you know, if someone is divorced or widowed and they remarry, and they don't change, you know, some of their prior decisions they made. First, let's touch on that for a moment.
Okay.
In a situation of divorce, if I don't, for example, retitle a home that I might have with my former spouse, well, if that's a joint with right or survivorship and I pass, even though I'm remarried, my ex-spouse
will get the house.
Will get the house.
That's significant.
It sure is. And it's not something that, you know, the attorney's going to necessarily follow up on. I'm sure it's often written out and the instructions are there, but it's truly up to the individual to make sure that it does in fact happen. Changing beneficiaries, you know, on 401k plans or other retirement assets. If you don't go through the process of actually changing that, either to a new spouse or to children or whomever you want, you know, it's going to pass based on what's there and what was there even prior to the divorce. So
you bring up an excellent point, because I know that is an area that people simply overlook.
Yes, they do.
They just do. The issue of beneficiary designation and even the language of that beneficiary designation, to make sure that it passes to their son, and perhaps they don't like the daughter-in-law.
Right.
And they want the assets to pass to the son's children. But if the language is not written properly, it may very well pass to his wife.
Exactly.
And then they're there wondering, how did this happen? That's interesting. Continue.
Sure. Some of the other issues would be, you know, you do actually remarry, and say you do draft a new will, and you know you're in what you now feel is a long-term relationship, and so you leave assets to this new spouse. You may change your beneficiary designations, you may retitle the house, you may update the will. Well, if, for example, then you pass and now the new spouse has all the assets, you have completely disinherited your children.
Your children. My goodness.
That's something that I think is probably often overlooked and people don't realize. And again, that's maybe where you come back into the, well, I'll trust him to do the right thing. He knows that I want my children to have my assets. And I very often counsel clients that, yes, right now he does, and right now you do, you know, but the issue is we don't like to leave things to chance. People change, relationships change. Right. And that's, you know, that's actually an area I'm dealing with right now with a current client who just remarried.
Okay.
And we're in the process of updating her estate plan. And while she would like her current husband to benefit from her assets, we discussed and I walked her through the process of ensuring then, by use of a trust, that those assets upon his death ultimately come back to her children.
To her children, rather than possibly if he has children.
Right, exactly.
And then literally cutting off your children, and his children getting all of your assets.
Exactly.
That's a very real thing today.
Yes, it is.
Because you do bring in this blended family scenario where you have your children, his children, and maybe even new children that were birthed out of the relationship.
Exactly.
So you're now looking at 3 sets of siblings, all of whom should have some type of an inheritance. But again, that's careful estate planning, would you say?
Absolutely. Absolutely.
Okay.
And again, you know, the kind of thing where as we were discussing a moment ago, we don't do this just once and set it on the shelf forever. But we do revisit it, and we just, you know, no different than going to the doctor for your annual checkup.
I think there's just such a misunderstanding, perhaps, because many people think this is going to be so complicated and so expensive and so emotionally trying, because you are going to have to make some decisions as to how things would be handled in the event of your death. And it's a tough subject for people to even contemplate.
Often it is, you're right. And you talk about if you die. Well, the reality is it's when you die.
When you die. Thank you, Kathleen.
We don't have a choice
Thank
in that
you.
one,
You're
right?
definitely leaving here at some point.
Exactly, exactly. And so, you know, we really counsel clients on the importance of really giving it, you know, thought now. And it's not so much the focus on your actual mortality, but it's truly the focus is on what are your goals.
Okay.
You know, what are your hopes and dreams? What are the things you'd like to see, and how, you know, the wealth that maybe you have created over your life, how would you like to see it used when you're no longer here? What are the, you know, what are the things you would like to share with your children about where that wealth came from? What are your hopes and dreams for them in terms of how they might be able to use it to further themselves and further society? It's really, truly, you know, all about making the decisions while you're here and you can, and revisiting it.
With a caring advisor.
Exactly.
Because
a trusted advisor.
A trusted advisor. I would have to agree with you on that. That's such a very important thing. Why do you think that so many women have difficulty in making decisions, particularly as they get older and they may find themselves having to now, having dealt with the death of their spouse, now having to look at their own situation?
Sure, Michelle. And, you know, it's not so much, I would say, that women need estate planning more so than men. I mean, clearly we all need estate planning, but historically, you know, in our society, you know, in the traditional family, men often, you know, controlled and planned the financial affairs of the family.
Yes.
Especially in older generations. And with, you know, statistically, women still outliving men, very often they're the ones who ultimately wind up with the financial assets and the responsibility for those assets. And they may or may not have had a very active role or voice, you know, in creating the estate plan that still exists today. And often, I think women are a little reluctant, especially older women, in following the death of a spouse. They're reluctant to ask questions or to even consider changing an estate plan out of perhaps, you know, respect for their deceased husband, and something they may have set up together, you know, decades prior that may or may not still fit for them today, and for their, you know, the relationships that, you know, now exist in the family, or, you know, just to revisit how was that really set up, and does it still align with my goals and objectives today? I think a lot of older women perhaps are reluctant to ask questions because they feel like it's something they're already supposed to know.
Wow.
And may or may not have had a good understanding of it at the time it was done, and perhaps less so today.
And yet the times today are so significant because we are living longer.
Exactly.
And women are living much longer.
Right.
And statistically remaining unmarried.
Right.
They don't remarry after their husband's demise.
Right.
So now they have the challenge of, can I live on these resources? And I don't understand. So how do you address that?
Really, you know, for someone who's already experienced a death, it's about looking at, you know, okay, what do we have to work with, and how do we make it work as well as possible?
Okay.
In terms of the overall plan.
Okay.
Do we need to start generating income now? Do we turn on Social Security? And when? And how do we make, you know, maximize that benefit? Do we look at maybe needing to go back and have some earned income for a while? So there's lots of, there's lots of different ways to accomplish that, given, the needs of the widow and what they have available in terms of resources to work with. There's no one sort of cookie-cutter approach for that one.
I appreciate you saying that, because everybody's situation is uniquely unique to them.
Exactly.
And as an advisor, you would be looking at their own individual circumstances and constructing a plan that would work for them to meet their needs.
Right.
Another concern I have as we look at estate planning is, what does one do in the event one has to go into a long-term care situation? Does the estate plan no longer have value or whatnot? With that being an emerging concern. So many people are having to make those financial decisions today.
Right. Well, ideally, and I would say where we often counsel clients now, is to come up with a plan for that potential, potential long-term risk of needing to, either bring in home health care or perhaps go into some sort of a facility at some point in their lives. So ideally, that's being addressed early on. It may or may not have been addressed for older folks now who are faced with that decision. And, you're looking at, what are the resources, again, to perhaps provide for that care, and that can be quite expensive, $6,000, $8,000, $10,000 per month.
It's frightening.
Exactly.
Kathleen, it's absolutely frightening.
And you look at, how long how much time will my resources, my financial resources carry me? And then you look at, the type of facility, and often it's the children or perhaps a spouse looking at the, Alzheimer's is something that is affecting a huge percentage of the population. And, those facilities are relatively limited in terms of the number of them out there that'll actively serve Alzheimer's patients.
And they're expensive.
They're very expensive, and most of them are private pay. They don't all take Medicaid, which is what kicks in when you do exhaust the resources and you don't have anything left more to pay, then Medicaid kicks in.
Which many people do not understand, that Medicare is not Medicaid.
Exactly.
That Medicare does not pay for long-term care.
Right.
That's Medicaid, and that's only when your financial resources have been exhausted.
Exactly.
And then here you are with very little.
And limited, of course, in the facilities that you can even go to. That will take Medicaid patients.
So when we look at this whole area of estate planning, certainly that's a part of it, and looking at where they are, where they want to be, and how do you put all of the pieces of a puzzle into place to make sure that their older years are optimized. Not to say that young people don't cross over, because they die too. The cemeteries don't discriminate. They're young and old. But certainly, when we look at where the propensity of activity is, the older you are, the more the probability that you'll be leaving sooner. And again, the more the need for this type of foundational planning. So if we had to summarize, we need the will. And that's where it begins.
Exactly.
And then you also need, you mentioned your durable power. And what does that involve?
Well, there's two of those. Again, there's a durable power for health care, where you're authorizing someone to make health care decisions for you if you become incapacitated and no longer can. For example, you're in a car accident and you're unconscious. Someone needs to be able to ideally step in and make the decisions with the doctors on your behalf. You also have a financial durable power of attorney that gives someone the authorization to make financial decisions on your behalf, again, if you're incapacitated or unconscious or terminal, you know, and drugged, whatever the case may be, even to go on and pay your bills. So those are two very key components. And the third part of that package that, you know, what we refer to in the industry as advanced directives, is the living will. And again, these three pieces are essential components regardless of the amount of material wealth you may or may not have. So this is where, again, the very basics for what any person needs is covered. And the living will is where you're actually specifying what you want with regard to life-sustaining or life support equipment if you essentially become brain dead, you know, no longer functioning with no hope of recovery, whether or not you wish or do not wish to be put on life support.
So what happens, and I say this not being critical, but in many situations, a will is prepared, but the ancillary documents, the advanced directives, are missing.
Or not signed. They
never
got signed.
They never got signed.
Yeah.
And something occurs. So how does this play out? They don't have an executed durable power for financial, durable power for health, and no living will.
Right.
So how does this play out in this tragedy that's unfolding?
Well, it's a mess, quite literally. And you may, you know, you've suddenly got often children, or perhaps, you know, a spouse or even a second spouse trying to collectively make decisions about what mom or dad really would want, and to what extent would they want us to go, you know, from a medical perspective and try to prolong their life. And very often you've got disagreement, which makes it that much more difficult because these things weren't discussed and communicated in advance. And at the same time, you often have, you know, a real short window in which to make a medical decision. So it's very, you know, can be terribly trying.
So what happens? I do know of situations with the absence of a living will where the medical professionals determined that they wanted to continue the life support, and the family did not.
Right.
And in the absence of that directive, it got pretty heated.
Exactly. And then, of course, we all know of, you know, very prominent cases like the Karen Quinlan case, where
Karen
she was
Quinlan.
on life support for years, and at real odds between her husband and her parents.
And we could feel for both sides.
Exactly.
It would have been nice if that would have been done.
It would have been nice if Karen would have specified her wishes in advance. So that they could have avoided, you know, this long, drawn-out, costly battle.
The angst of watching it. I was just saying, why? Just such a little paper, but so very, very important.
Exactly.
Now, do you have any thoughts as we look at the durable power? And one of the things I do share is that be careful who you name to act as your attorney in fact. And would you like to talk about that?
Sure. You know, when you're thinking about who you would want to step in and make decisions for you, it clearly needs to be someone that you trust implicitly, that you feel will act in your best interest, that you have communicated your wishes with, and ideally you've let them know, you know, or reminded them perhaps, because they need to sign too sometimes, and accept that role. So it's important that, you know, it be someone that you have a very high level of trust and confidence in.
Right, and many times it may not be the children.
Exactly.
It may be a friend, or it may be your attorney or your banker or a trusted advisor. It's not necessarily children.
Right.
Because they have their own lives, and this may not be something they want to do.
And it may not be the same people that you perhaps name for medical
and
for financial. Just like you said, you may choose perhaps to name adult children for medical reasons, but unless they've demonstrated, you know, a certain level of financial acumen, you might choose to, at least for a period of time, name someone else.
I think that's very important because I've had situations where they wanted to name two people on a durable power, and because they didn't want animosity.
Right.
And so they have two daughters and they want both of them. And of course that's tough because someone has to make that decision if you're not able.
Right.
And the more people you put in the pot, the more possibilities of disagreement.
Exactly.
That's one of the things I share with people.
Yeah, so while, you know, you may think that you're doing the right thing, perhaps, in naming two children or three children for that matter.
Oh my God.
You could be opening up a whole can of worms with respect to their individual opinions on things.
Right.
And their perception of not only how they themselves want things done, let alone their perception of what your wishes are. And there may be very significant conflict between them.
Well, particularly as we look today where children are so scattered.
Exactly.
And you have a child in Boston, a child in Los Angeles, a child in Atlanta, and then all of a sudden all of them are on an instrument that many times people neglect to tell them.
Yeah.
I actually had a situation where one of my clients died unexpectedly, and she did not tell the two people she named as her executrix that she had named them. And both people were out of town and had no clue where anything was, and did not have any clue as to what the responsibilities of that particular designation even meant.
Right.
And so I just feel that this is something that, again, a trusted advisor is so critical to ask those questions.
Right.
You know, and she did have an attorney, but those questions were never asked. He did what she told him to do, but he did not ask those questions that I think should have been asked, so that she might have considered carefully before naming people in such a sensitive position and not notifying them.
Right.
That has to be one of the most difficult positions to be in.
Exactly, especially if you're out of town and you don't have any sense of where things are. That's a great point, and also, and again, another reason to, for one, not only consider and communicate with a person that you're asking to step into those roles, but you know, revisit it periodically, because relationships change. They
do
evolve,
change.
and you know, it may or may not, you know, might have been a good idea at the time you did it the first time, but 5-10 years later, you know, it might not be the same person you would choose, or perhaps children have stepped up and matured at a level that they're ready to step in and make those decisions for you.
Parent.
Yeah.
What about, because not only are we seeing multiple marriages, Kathleen, we're also seeing people on the move, which is they may have set up their will and their estate work in Ohio, but they're now snowbirds.
Exactly.
And they live in Florida or they live in the Carolinas, but they're no longer domiciled in Ohio. Do you run into that type of thing?
Sure. In fact, it's very common. And again, all the more reason to revisit your documents when you do move. Make sure especially that your advance directives, again, the durable power for health care, for financial, and your living will are current and in effect in the state that you currently reside in.
Because what was executed in Ohio may not have legal standing in Florida.
Exactly. Or Georgia,
or Georgia,
Arizona,
or wherever.
Wherever else you may decide to move to.
I've come across that not often, but enough to make me concerned, because I think the assumption is that people think that all states recognize legal instruments the same.
Exactly.
And that's not the case.
Right.
That is not the case. So
Right.
in a situation like that where they may have a home here and a home in Florida, the rule, of course, of where do you live the longest would be most important in terms of the instruments. So the attorneys and that group would have to execute instruments in that state.
Exactly. So wherever you are determined your legal residence, you know, your state of domicile, is where your documents need to be drafted and reflected based on current state law in that state.
What do you do with people that have multiple properties in many states?
Great question, because that's not terribly unusual either.
It is not.
One of the easiest things to do with that is to put them in a trust, so that they are not then subject to the estate law, the state estate tax laws of each state that they're in, but that they pass via a trust as opposed to a will.
So if they have property in, say, Chicago, property in Cincinnati, property in Philadelphia, through the use of a trust venue,
right,
they would not have to probate all of those different assets and pay the taxes in each state relative to that asset.
Exactly.
Do most people think about that?
Absolutely not.
They don't. Oh.
No.
So what happens?
Well, then you've got probate court open and active in a state,
in
every state in which you actually own any type of property or asset. And it just adds to the complexity and the expense of settling your affairs.
To the heirs.
Exactly.
Okay, to the heirs. And if a person doesn't have a will,
then you're back to the laws of intestacy
for
in the
every state.
Exactly.
My goodness. I know that in the South, this is a problem with so many people where heir property is completely muddied from the death of a person, maybe 2 generations, and this property is still not been probated. I don't even know how one works through something like that. If you're into a 2nd or 3rd generation where the property is still on the books as titled to an individual who has been gone for many years. And you hear families say, well, we all have an interest in the property, and I'm trying to understand
legally what really did happen.
What really did happen, and how ultimately the property winds up being lost for delinquent taxes, failure to probate on a timely basis, and a number of things, all because the person did not understand the necessity of estate planning.
Right. And you know, Michelle, there's many issues with regard to real estate, you know, be it second homes, that, you know, people may have the vacation home, you know, at the shore, for example, that got passed down through generations. In addition to all the things you're talking about, there's really just providing for the simple upkeep and the maintenance, which can be very expensive.
Yes.
Let alone property taxes and insurance. But the cost of maintaining a family heirloom, so to speak, and, you know, is something that often, again, is left out of the planning process, in addition to the importance of ensuring that the documents are in place to pass it as efficiently as possible to the people that you ultimately want to receive it.
So let's talk about the role of insurance in estate planning.
Okay.
And what role do you see playing? Because many people think insurance is just for burying a person.
Right.
And what is your perspective as a advisor?
Well, it's really pretty simple. Insurance creates a block of capital at the time of passing. It's a financial tool, and you know, from when you're young and you've got a family, insurance is imperative in terms of making sure that the surviving spouse and the children are taken care of should something happen to, you know, one of the spouses, assuming they're both a breadwinner.
Yes.
It becomes even more critical when you've got the traditional family where you've got one being a breadwinner and one being a stay-at-home spouse. So it's about creating a block of capital at the time when you need it most. From an estate planning perspective, and of course the laws of estate in our country are evolving as we speak.
Literally.
Yes, yes. We've got, you know, a reprieve through the end of this year with regard to the unified credit at $5 million, and then who knows what's going to happen. It may sunset and we'll be back to a $1 million credit, which is the equivalent of, call it a coupon, and the ability to pass up to whatever the unified credit is. Again, right now it's $5 million onto whomever you choose, be it family or other heirs. And
that's through the end of 2012.
Exactly. So depending on what happens with our estate tax laws, you know, there can be some very significant estate taxes levied against an estate. And so the use of insurance comes into play to position a tool, and done rightly, it's often placed in a trust outside the estate, so it's not part of the, you know, tax base of what's part of the estate, compounding that problem by having it inside. But it's placed outside the estate in a trust to ultimately provide for the payment of estate taxes in a very leveraged way.
Okay, and when you say a leveraged way, we're talking about pennies on a dollar.
Exactly.
That's one of the power. I tell you, I love insurance because I've seen it create tremendous opportunities for generations. It's more than just burying a person.
Right.
It literally gives money tax-free to your heirs.
Right, or perhaps to, you know,
charities
and institutions.
Right.
If you'd like to endow something.
Powerful vehicle.
Very effective way, very efficient way to do it.
Right. So that is a component of estate planning as well. This is such an amazing subject. Are there any other areas that you'd like to cover in the remaining time we have left?
You know, Michelle, there's one I would like to cover.
Okay.
You know, the focus of what we've talked about so far has a lot to do with the financial aspects of estate planning. But one of the things that, you know, gets talked about a little bit, but perhaps there's less of a real process to go through, are the other assets that we all have to pass. And those are perhaps sometimes the intangibles.
Okay.
The family traditions, the family stories, the connections to connect the generations from one to another. It's not just monetary wealth that does that. In fact, often those are the families that fracture, who haven't actually prepared their heirs for the wealth they will one day inherit. I mean, think of it no different than having a blueprint for a house. You know, you have a plan to build a house, and the architect can follow, and, you know, the architect probably created it, no different than, you know, a qualified attorney creating a document, you know, be it a will and a trust. But you have to look at what really makes that house a home, and it's, you know, it's the paint colors, it's the landscaping, it's the, you know, the
memories,
the pictures on the wall, the
memories
of what happened in that house over all those years. And from an, you know, those are the things that you know, the photographs of the family members throughout the home. That's what really makes that house a home. And from an estate planning perspective, and this is again true for everyone, it's not, you know, it's not just the ultra wealthy. I think it carries it carries on to a different level because of the opportunities that wealth creates. But it's really about learning how to, and walking clients down the path of creating their legacy. And at Resonate, my partner Barb Culver set up a separate company called ConnectGens that is about connecting generations, hence the name. And she has developed a process that we use to walk people down that path of how to create their legacy. And part of that begins right now while they're still alive. It's something we all do every day. It's about, you know, sharing the family traditions. It's about sharing the purpose of the wealth, or the history of where the wealth came from, or the dreams that the wealth creator may have for those who will inherit it one day, the opportunities they wish for them, the wisdom that they learn throughout their life, you know, that they really wish to impart to their children, things that sometimes we may take for granted and think we've told them that along the way.
Yes, yes.
But those are often, and what we hear from heirs is those are the far more meaningful part of the estate plan to them when someone has passed.
Yes.
Be it in a letter form, or we do work with some attorneys, John A. Warnick, for example, who developed the whole purposeful trust system of incorporating the voice of the grantor, the
talking
decedent.
to a person.
Yeah,
Actually,
so that the
that's
trust
wonderful.
is not written in just legalese, but it actually captures the voice
Of that person.
of that person
That
in
is
the document
so,
itself.
so beautiful.
And so that's
so beautiful.
a huge part of estate planning that, you know, most advisors do, I would say, a pretty good job of the technical side, and that's, again, the bulk of what we've talked about. But, you know, bringing in the softer side, or the what we'll call the qualitative side of planning, is something that most families need, and very few have a process for actually walking them, you know, and tools to use to walk down that path and create one.
I think that is so beautiful. I know that I ask my clients if they would prepare letters of instruction, which is not a legal instrument, but it does serve to convey their thoughts in terms of how they want the funeral handled.
Exactly.
Thoughts concerning their children and grandchildren. What is their vision for their family? Because it really is all about family, Kathleen.
It is.
In the final analysis, money cannot make you love or be loved. It's the family. And it's those shared expressions that define one's life story. When you birth and marriages and children, and all of those things make it so, this life on earth, so very, very amazing. And so I just would like to conclude today's thinking by summarizing to my viewers. We've covered a lot today. The necessity for estate planning, the advanced directives, which is your durable power of health care and financial, as well as your living will. We've talked about the importance of the legacy. And actually I think that trumps everything, because the money gives content, but it's still about the story. And every family has a story, and our elderly are the repositories of that story. And I just feel that that is such an awesome thing that you all are doing, and certainly you have my support. I would like to conclude the interview today in the remaining time that we have. Is there anything that you would like to say again for those of you that are viewing? I'm interviewing Kathleen Marteney, who is a partner with Resonate out of Cincinnati, Ohio.
Actually, I'm not a partner, so we'll need to edit that part.
Okay, that's fine. Well, I don't want to misquote, but you are an affiliate. You're a member of Resonate Incorporate out of Cincinnati, Ohio, and you have been in this industry for almost
17 years.
17 years. That's impressive. Working the financial affairs of today's consumer and specializing, I'd like to think, in the whole area of estate work and widows and legacy. Is that a fair descriptive?
That's a fair descriptive.
Okay.
We do comprehensive planning, and of course all the traditional investment and accumulation side as well. So it's not an exclusive thing. But
but it's nice to know. Because there's a tremendous need for what you bring to the table. And I might also say your compassion and your gentleness is something that will go a long way in a tough industry. And I really do appreciate you giving me your time today to talk about this very, very important subject. Certainly it's something that I feel very deeply about. And I just wanted to thank you for availing yourself of this time to share with our viewers. And hopefully they will communicate with you. We'll make sure that's on the screen.
Okay.
And so that they can reach you. And I certainly only give you my very best, and I thank you so much for joining me on this segment of The Power of Money. And I'd like to just conclude by saying to all of you, my viewers today, that if you have not ever given thought to an estate plan, I'm going to challenge you and I'm going to charge you to make that a very high priority. It doesn't matter what area, what age you are, estate planning is foundational and fundamental in your financial lives. And the purpose of today's Power of Money was to bring you into the world of estate planning and to make it a process that you could begin to understand why we need it and why it is so very, very important today. I'd like to conclude by simply saying that, as always, I'm your host, Michelle Graves, The Power of Money, and I thank you so much for joining us on today's segment. You be blessed. Have a great day.